Coconut Creek man says he's been renting a home he owns for years.
Then, abruptly, his association made him stop. It's tonight's edition of Help Me Howard with Patrick Frazier.
It's a 2-bedroom, 2-bath.
10 years ago, David Dominic bought a townhouse to rent out in Coconut Creek.
An investment property. Everything's ran fairly smooth for 10 years.
The main reason David bought at the Village of Blue Lakes is because the association allowed the owners to rent their unit, which some associations won't allow.
That was the sole purpose of me purchasing here, because you were allowed to be an owner and rent out your property.
Since 1992, the association has had a rule that only 29 units could be rented at any given time, but they ignored their rule. Then last fall, they sent this letter letting owners know they were going to enforce their 29-unit rental policy.
I've received no notification of rule changes. I've received no notification of violations that I'm in.
Then in the middle of August, David got this letter from the association reminding him that only 29 units could be rented out, and that David's unit was not one of the 29.
And in order for me to get approval for the tenant to live here, I had to evict my tenant, get written approval from the board, and then be put on a waiting list to be able to re-rent my unit.
That means David's tenant will be evicted, and without the rental income, he won't be able to afford his townhouse. Not the way he says an association should treat a long-time owner.
As long as I've owned the property, my homeowners association fees have always been on time. Any assessments have always been paid in full on time. And I've always had a unit that was occupied with a tenant.
Well, Howard, can an association enforce a rule they've ignored for years, forcing an owner to break a lease with his tenant and throw them out?
An association cannot suddenly enforce a rule that they have been ignoring. To enforce the rule, first they have to republish the rule, then mail that to the owners at the address they provide. Then they can begin to enforce the old rule again.
The association's attorney said they mailed the notification to David, and we also saw the notice posted in a display case on the property. David says he didn't get the letter or see the display case. He then went to the board meeting to plead his case. Turns out he was lucky. As of that night, only 28 owners had received approval to rent.
It's first come, first serve. It has no bearing on who you are.
Only owners were allowed in the meeting, but David was in decent shape since one more owner could rent. The board's attorney, Rhonda Hollander, told us if David submitted the proper paperwork immediately, she would talk to the board for it.
I'll ask them to hold off on removing the tenant, even though a violation is currently in existence. If we can get it approved and there's an opening, no problem.
Rhonda did as she promised. David filled out the paperwork.
They did say they would accept my application.
A few days later, the application was approved. David's renter can stay.